Hi, everyone. Welcome to our first Dean's Dialogue session. Uh, hey there. I'm Adam Chilton. I'm, as of July 1st, the new Dean of the Law School here at the University of Chicago. And before we jump into today's lesson, I thought I'd just briefly talk about the idea behind this lesson. Or this webinar today. So as I mentioned, I'm the new Dean of the Law School. However, I've spent my entire academic career working here at the University of Chicago. And to me, the thing that is so unique and so special and different about the University of Chicago is the intensity of the level of engagement of the faculty and the students and the broader intellectual community here at the university. To be honest, if you spend time at the University of Chicago and then go spend time at any of our peer institutions, if we were to have such a thing, you'd immediately realize just how less intense the environment is. Here, people are in their offices in the tower. For instance, Judith, Will, and I are a few doors apart right now on the fifth floor of the library. And the building is full even throughout the summer for our workshops and for other lunches and events. And the same is true for the student experience. Now, an animating principle of that is not just people are together in physically the same space, but people are engaged about talking about substance, that is, debating ideas, events, issues, etc. Now, as a faculty member, we have regular lunches on Monday, Wednesday, and Friday, where we discuss different topics and issues. And to me, that's what makes being at the University of Chicago so exciting, is that whenever there's a new Supreme Court decision or major current event, that you can go to work and hear the smartest minds in the country tell you what they think about it and what they know from their areas of expertise. And so as dean, one of my goals is to try to do what we can to bring more people into some of those discussions. Now, we have a range of different ideas that we're going to pursue, but one of the first is this Dean's Dialogue series, where I'm going to have regular Zoom conversations with my colleagues, where we're going to, in a non-prescripted conversation, discuss some current topic that I think would be interest to me, that I would like to learn about, and that I would hope that you would like to learn about too. So let me just briefly say, if you have ideas, thoughts on topics that you'd be interested in hearing about for these sessions, please feel free to email me and send me those ideas, and we can look for scheduling potentially some of those ideas for future sessions. All right, so that's the idea. That's what we're trying to do here today and in future sessions. Now, for our first session, I'm joined by my colleagues, Will Baude and Judith Miller. So let me just tell you a little about Will and Judith before I then discuss our topic for today. So Will Baude is the Harry Calvin Jr. Professor of Law, and he's also the faculty director of the Constitutional Law Institute here at the law school. Will teaches a range of subjects, but including federal courts, constitutional law, election law, conflicts of law, and something that you all know something about. Will also is one of our professors of elements of law. Now, Will's current research interests include judicial remedies that are available against the federal government, the Supreme Court's emergency docket. Though some of you might not know, Will coined the term the shadow docket, which has taken off over the last few years, and as well as, importantly, originalism broadly defined. Now, Judith Miller is a clinical professor of law in the Federal Criminal Justice Clinic. Now, Federal Criminal Justice Clinic is the nation's first legal clinic devoted to representing indigent clients charged with federal felonies. They pursue impact litigation through criminal cases in federal court, and they engage in systematic reform of the federal criminal system with the goal of trying to combat inequalities. Judith teaches a clinical seminar as well as doing this, and that covers skills training, lectures, guest speakers, and more. She does this along with Allison Siegler, who she co-runs the clinic with. Now, prior to joining the University of Chicago, Judith was a trial attorney at the Federal Defenders of San Diego. At Federal Defenders, she represented indigent defendants accused of federal felony offenses all the way from arraignment through appeal. All right, now, here's why we're here today. Will and Judith, this last year, organized a class that they taught at the law school called Litigating Originalism. I'll let them discuss more about this, but I think at the most basic level, Will is an originalist, Judith is not. Will is focused primarily in litigation at the Supreme Court and the highest appellate lawyers. Judith is a leading trial attorney that is in the courtroom litigating cases, and they're trying to grapple through what originalism means for actual litigation. And this seminar that they designed and taught in a very University of Chicago thing was nominated for a university-wide diversity award this last year, and it won the award because it brought together people of different views and ideas together. And I'm curious to learn about what the seminar was and actually what litigating originalism was all about. So I'm going to stop there and ask this question. Tell us about the seminar, Will and Judith, why you designed it, what it was, what's the idea behind it?
Well, I'll start with the kind of the impetus for it, and then maybe, Will, you can describe some of the nuts and bolts. Sure. All right. So I think that there's just this increase as a litigator in the trial courts. I think there's an increasing need to be able to make originalist arguments. That's, on the one hand, sort of courts want to hear originalist arguments. There are more and more judges who describe themselves as originalists. That's at all levels of the judiciary. The Supreme Court is certainly increasingly originalist. I think even judges who wouldn't just necessarily describe themselves as originalists are still, they're interested to hear these kinds of arguments. So it's important as a skill issue that we be able to make these kinds of arguments. There's also something disruptive about originalism, especially for my clients, for whom sort of the law is typically not especially favorable. In part, of course, the government gets to choose which cases they bring. They don't bring cases that they don't think they have a good chance of winning, both on the legal issues and on the factual issues. And so something that kind of shakes up the system can be good for my clients. I guess I should say, and I hope it's okay to admit this in front of hundreds of people, but I did not feel like I had a great sense of how to make an originalist argument in the district court. I could see how you would do it in front of the Supreme Court, but when I thought about trying to make these arguments in my cases and on behalf of clients or teach students how to do it, I didn't have a great sense of how to do that. And so, we wanted to teaching a class is a way of forcing myself to grapple with the materials as well as working through the issues with students. And when I mean kind of how to do it, I mean really basic things like what counts as evidence, or what kinds of historical sources are authoritative as to which questions and which topics, or even what kind of historical sources are persuasive. How do you find those sources? How do you assemble them into an argument? What counts as an argument? What is a more persuasive or a less persuasive argument, or in terms of oral advocacy or written advocacy, or how do you assemble a record? Sort of the basic types of questions that I have pretty good answers to for other types of arguments that I'm making in court, and less so for originalism. So we wanted to put together a class that would focus on these kind of very practical litigation-oriented questions rather than the kind of big picture, kind of more research agenda type originalist questions.
So I similarly, as a in my research hat, when I think about the Constitution, I can take a year or 2 years to go away and read as many books as I want to, and maybe eventually come out and say, oh, actually, I've figured out the true meaning of Section 3 of the 14th Amendment, or not. Right? You're allowed as a scholar. In fact, you have to sometimes be able to come away and say, actually, we just don't know. And when thinking about the problems that practicing lawyers actually face, you can't necessarily just say, well, we don't know. Judges certainly can't just say, well, I don't know. And you've got a timeline and a sort of assignment of topics that aren't the same as what we try to do as our best practices as a scholar. And yet you want your arguments to be good rather than bad. And so what is it for the arguments to be better rather than worse? So our basic idea, because this sort of combined both of our areas of expertise and arguably exceeded either of our expertises individually, was to try to put the other class together, where we'd look at a series of case studies of times people had tried to bring originalist type arguments to the Supreme Court, to the lower courts. We brought in some guest speakers who had done this in very different contexts to talk about their experiences. And we brought together a group of students who were very different from one another. And the students, I guess I might say, similarly reflected the professors in having a mix of people who cared more about the litigating part of the class and people who cared more about the originalism part of the class. And it was a permission by instructor only class. So we sort of carefully put together a group that we thought would have a lot of strong but productive disagreements to try to figure out how to do it.
And it was really impressive the way that the students managed to I mean, to do it, to take this in good faith, to take it seriously. I think we could have, at any point, we could have gotten mired in some of the sort of either the intricacies of originalist theory, which respectfully, I'm just not interested in, or we could have, you know, been so practically focused that we weren't engaging with, in a sense, sort of the questions we came to answer in a kind of serious way. And I think everyone there managed to kind of jump in, do the project that we were trying to engage in. The students were just terrific. They were really impressive.
I mean, there's this moment you hope for in a seminar where the class starts to kind of teach itself. And so I confess, this may show how this isn't about us, but like it was an hour into our first 2 hour session. I remember the students we were reading a recent Supreme Court case, Rahimi, about the original meaning of the Second Amendment, and a bunch of different concurring opinions with various justices about theoretical issues that they thought relevant. And an hour into our first session on that class, I remember basically the two of us looked at each other. The students had kind of taken over, like
but in a good way.
In a good way. And then they were having a productive argument about, but why does Justice Barrett say this when Justice Kavanaugh says this? Does this really matter? And then one of the more original students said, well, I think he's not being totally candid here. And like both the sort of the moves across the divides in the class were like candid and productive, and students were kind of grasping on things and building off one another's points. I remember joking. I was like, I think we could leave now. Like they've got it. I mean, we stayed the whole class, but
yeah.
All right. So I'm curious to now. So it's interesting. So you set up this class. You're explicitly trying to draw students that you think are going to be ideologically diverse, and then different interests in the topic, some more from the litigation perspective, some more from originalism theory. What are now to get more concrete, what's a concrete example of a topic where originalism can come up in litigation that is not, as Judith said earlier, when I think of like originalism coming up in litigation, it's the Supreme Court talking about the non-delegation doctrine, or I guess the Second Amendment, or whatever it may be, but at the sort of like at the appellate stage. So at the litigation stage, what's an example of how this comes up, or could come up if you were being more ambitious?
Well, if you're being ambitious in my field, any constitutional criminal procedure issue is up for grabs, whether the Supreme Court has addressed it or not. And, right now, and not just constitutional criminal procedure, but then to some degree, the constitutional limits on substantive crimes as well. So I think the Supreme Court has been pretty clear that at least for the Sixth Amendment, originalism matters a great deal to how to understand what the scope and meaning of the constitutional right at issue is. You can take sort of Crawford, the Crawford Revolution, as opposed to sort of Crawford Confrontation Clause Revolution, pushing back on the doctrine that had developed that focused on essentially the reliability of an out-of-court statement. Instead, Justice Scalia, in this very famous opinion, wrote that the Constitution and what the Sixth Amendment requires is actually confrontation in court. You can look at the Apprendi and Booker revolutions on federal sentencing, that a jury needs to decide any factual issue that determines the sentence maximum and the sentence minimum. Now, those are cases that have gotten to the Supreme Court, but someone had to litigate those cases below in order to get there. So there's not just a question of, I think there's a question of preserving an issue what do you have to say in order to preserve the issue in the district court? But sometimes there are places where you may well be able to raise an issue because it's just new. I can say, without going into the details, there's something I'm looking into now where it's something fundamental and sort of universally accepted in federal criminal practice that is something that's essentially housed in the judiciary. Well, I recently learned that in the 19th century, this thing that is currently housed in the judiciary appears to have been housed in the executive, possibly exclusively in the executive branch. And I have not yet found sort of something overruling this sort of earlier point. Now, so there's a question, can I raise this issue in the district court at all? If I do raise this issue in the district court, how much research do I need to do in order to be able to know that this is essentially a non-frivolous claim, right? That there's sort of, I think there's this phrase, right? The past is another country. So we look at historical sources and things are always radically different, there might be a reason why things have changed, good reasons why things have changed since then, so that you can't really make a claim based on whatever the past source is or the past sort of doctrine is. But at the same time, when you find something that sort of find something like that is radically different from the present, could be transformative, and now with the aid of having sort of worked through a lot of the cases and some of the more relevant papers and talked with the students, I have a sense of how I would go about researching that question. We would look at 19th century treatises and try to trace a doctrinal path and talk to scholars and find some secondary sources. There's essentially legal scholarship addressing the issue that I'm thinking of, and maybe call up the scholars and talk to them and see what they say and how they can help me, and so on. And it's very resource intensive in a way that being in a legal clinic, I think, is essential, is sort of really important to being able to develop claims like that. But at the same time, it's fair game. And I think that a creative litigator can see lots of potential opportunities to raise these arguments. But of course, the difficulty is precisely what Will was pointing to, that unless there's a paper out there assembling the sources and making the arguments for you, it's tremendously resource intensive, and then it still may not work. So making these kinds of claims is pretty tough.
Got it. Okay, so I get the idea that anything is fair game within criminal justice, whether or not it's confrontation clause or sentencing guidelines or a range of topics where you can make arguments under, Fourth, Fifth, Sixth Amendment, that the way that the existing criminal procedure is done is inconsistent with the original understanding. Concretely, though, like, how do you enter these arguments? And by that, I mean, like, are you thinking at like the motion to dismiss, summary judgment, mill, like all of the pretrial judgment stage? Are you making these arguments? Or are you you bringing these out actually during trial, during opening and closing, or you have experts come in? Are you like crossing Will, during the trial? Or how does it work that you like enter the arguments at this phase, as opposed to just saying like, we're going to argue with, the Seventh Circuit about, the appropriateness of, to use Booker, using sentencing guidelines or something like
that? So one of the interesting phenomena that has happened is definitely the historian expert witness is definitely on the rise. And that's been especially true, of course, in gun cases where we have this Second Amendment doctrine that explicitly asks for historical questions. And so every major historian has written about guns, and some who haven't end up filing, expert reports saying, there were or weren't loyalty oaths to be able to hold a gun at this time, and here's what it means. Somebody recently wrote to us about his experience cross-examining several historians in a free speech case because there was a new campaign finance case where part of the question was, is this campaign finance law the kind that the founders would have liked or the kind they wouldn't have liked? And so he had to cross-examine a couple of historians, and he talked to other lawyers. People hadn't done that yet. And so how do you do that? So the regime that you, Adam, and some of our listeners may be familiar with for economists, where there are a lot of areas of law like antitrust or wherever else where economic experts and their whole economics firms devoted to figuring out how to bring in experts. I think this is coming to history in at least some areas of constitutional law, and already has.
I think just to add to that, though, it does seem, at least as a descriptive matter, it seems to be the case that the courts don't require you to have submitted all of your historical evidence in the district court in order to make an argument based on historical sources in the Court of Appeals or the Supreme Court. That seems to be somehow not a part of those kind of record limits. But in terms of your other question, sort of the how do you do it, when do you do it? It depends on the argument you're making, right? I mean, you could do it a motion to just depend. Is this something that can't be brought at all? Is there some way in which either the criminal charges or the civil case is outside the bounds of what can be brought into court? Well, then you would bring that as a motion to dismiss. I know less about summary judgment because of the nature of my practice and the sort of the hot minute that I worked in civil courts, and although I did clerk, but there's certainly motions in limine that you could bring that would be based on originalism. I can imagine jury instructions. Actually, I certainly can do more than imagine jury instructions that you could raise, that you could argue about originalism, post-trial motions, essentially at every stage. probably are not. I'm not sure yet how you make these arguments in front of a jury, but give me time.
I think one thing the courts are just still struggling with is the kind of literal procedural question of to what extent are these questions of fact and to what extent are these questions of law. Like when you cite an old case, you don't, that's a question of law. And even though there might be historical questions about like, is this really what the case said and what was Chief Justice Marshall really thinking? We like put that mostly in the law box. And one thing we saw is some just sort of disagreement among courts about which box to put history in, which would go to the question of, do you give this to a jury or not? That's something they're still kind of arguing about. There used to be a thing called the legislative fact, which is like a fact, but a fact that's kind of a fact that judges figure out rather than juries. Maybe it goes there. That's one of the many problems we were kind of wrestling with.
Got it. No, that's interesting because it makes sense that, right, if it's just like what the old cases say, whatever about the Second Amendment, that's different. But post Bruin, if we're like having to put on a historian to say like, in the Wild West, did people have open carry or not, or something like this? Right. That feels distinct.
Yeah. So I think California or some state had you have to have good character to get a gun license, and so they're trying to defend this, even though after Bruin you're not supposed to have really discretionary standards for giving licenses, and so they brought in experts to say, well, after the Civil War, they didn't let Confederates have guns, and that was like a good character requirement. And the historians are like opining on how much it was like a good character requirement, and is that likeness question a question of fact or a question of law?
Right. I mean, there's a bit of merger or sort of squishiness to this. I think, Adam, you just said, well, and if it's just about citing old cases, but if it's citing a bunch of old state cases and old state laws and maybe one or two federal cases, is that a legal or a factual point? Are you sort of making a descriptive point about practice and what people did and where you might want a historian, or are you citing old cases and saying, well, this is what the cases mean and this is how we put the doctrine together? And then, of course, at least when I'm looking at older sources, I often have to look at some kind of secondary sources just to understand what did the words even mean? What's the context to understand, the writs, not something I was taught.
All right, so this is interesting to me, thinking through I got to say, I've not spent any time thinking about like the historian as expert witness in run-of-the-mill federal felonies of possession cases or gun possession cases or drug possession cases or whatever it may be. So as Will alluded to, in the context that I know better, which is civil cases like antitrust that involve economic experts, it's been over the last, let's say, 40 years, the ecosystem that has emerged of, professional expert witness firms that has impacted both academics and PhD economists that go into this full time. It's produced an interesting ecosystem where, for instance, one thing that I've always found frustrating as a scholar is that there are many people where, even though they might have a primary background as an academic, if you get particularly deep into expert witnessing, people become afraid to say anything in their scholarship because they think, oh, I'm a defense side witness here. It's important to me to have scholarship that is consistent with that. And so there's ways in which it's been at times corrosive for the academic process. At other times, it's been extremely useful to have this interplay change between the academy and actual practice, et cetera. But it's complicated, and I think we all know that. Is that starting to happen with historians, or is it still too new where people are not yet, full-time Second Amendment witnesses or something like that?
I mean, I hate to say it. I think arguably it's happened to constitutional law in a deeper way, maybe some time ago, right? So many people who are constitutional law or constitutional history professors have one eye on the kind of bigger picture question, and is a common complaint about scholarship that it seems like it's written with an eye towards litigation by the Supreme Court. So I know I'm a constitutional scholar anyway, and I like to think that I and everybody here are different, but arguably that's just like part of having a law school is that we're doing something incredibly relevant, and therefore we can't pretend that we're just in an ivory tower.
So I was going to answer that question almost
the
opposite, but I think because it's from a different perspective, at least from what I see, I think it's the unusual exception rather than the rule to have a historian expert witness. It's not that it never happens, but it seems to happen very rarely. And then once, at least in criminal defense, once there is an expert transcript, other people will cite it. Because remember, a lot of the time the court is paying for the expert, and the court may not want to pay for an expert, or, the court may, there may be times when an expert is truly essential, and the court will pay for the expert then. But having testified once, the transcript is then available for other people to use, because it's sworn testimony, especially if it's a pretrial matter. So I think it's interesting. It's an interesting point, the sort of the broader point about constitutional law, but at the same time, in terms of the actual in-court practice, there doesn't seem to be a ton of expert witnessing, historian expert witnessing, at least not yet. Of course, that might change as we see these doctrines and these challenges develop over time.
So in the criminal context, my instinct would be that in the criminal context, that it would only be defendants that are raising these arguments initially, right? Once they're raised, you can imagine them being responded to by the government. But I would assume that in the criminal context, the government is comfortable with whatever the status quo is on the confrontation clause or whatever it is they want to charge under, they believe is legal and constitutional. And you were saying, like, you did not follow criminal procedure correctly. This kind of crime should not be a crime even, or whatever it is. And so here's why I'm asking this. I could imagine that that litigants are only going to raise originalist arguments when they have done some research and they've talked to a historian and they've talked to law professors and they've looked into the situation and think, like, I have a good originalist argument why what the government is doing is wrong, and it is pro-defendant, right? And so what we're going to see is this weird adverse selection where originalism is used at the trial level in criminal cases exclusively in a pro-defendant way, and only when the history has, some degree of clarity enough that the trial level litigant thinks that it's worth raising the argument, right? You're under no obligation to say, by the way, I'm going to bring up some history that's bad for my client, and actually, you could tighten up this law or something like that, right? Any risk of this?
Interesting to call it adverse selection, because you might think also maybe that's, if you think of originalism as
oh, right, yeah, sure.
Well, if you think of originalism as one ingredient of our law, I think it's just descriptively true that it's the most useful to make as an argument when you think something is wrong with the status quo. Like the day-to-day still is like, oh, there's a statute, oh, there's a case, okay, we don't have to think about it too carefully. And the times across lots of areas when originalism argument starts to pick up steam is when somebody wants to say something has gone awry here, we need to rethink it. So it might be that it's true in general. You'd see it only when somebody thinks they've got a pretty good claim that it's time to change the status quo, and that the other X% of the time it doesn't change. I was thinking there has been this movement that some of the justices in the Supreme Court picked up on to, for instance, reconsider the exclusionary rule under the Fourth Amendment, the rule that if evidence is illegally seized, it can't be used against the defendant, which probably didn't exist at the founding, and Joseph Story wrote a famous opinion saying was not the law back in the 19th century. So you could imagine a world where, like, the Trump administration or the Idaho Solicitor General's office decides to push this argument. I don't think they've done that, and maybe there are good reasons for that, but you can imagine that happening.
I think that this is the question, though, that I think Adam was pointing to is sort of the district court level litigation, where, I think that it's generally the case that I think, as I said earlier, when the government brings a case, they've already sort of assessed the state of the law and the state of the facts and have concluded that they have a good chance of winning. And so there is a kind of, I don't want to call it a status quo bias, because there are certainly creative litigation that the government undertakes. I'm not trying to dismiss what government attorneys do by any means. But it is the case, they aren't usually starting on the back foot. I think they can just choose not to bring those cases. So I think it is the case that this sort of disruptiveness is sort of it is that to some degree that's probably true. Although I don't think that that would necessarily be the case just in criminal cases, and civil cases as well. Of course, there are sort of impact litigation. There's cases that where people are sort of necessarily trying to push the boundaries of the law. But my understanding is that sort of when one company sues another, the first company doesn't sue the second company unless they think they can win, or they have a good chance of winning, or at the very least that they can get a decent settlement. So maybe I'm getting over my skis here, but I don't know that. I think that the point that it's you raise an argument, you try to change the status quo when the status quo is not working for you, is not just a criminal defense issue. That's something that extends more broadly, but you probably would see more originalist arguments anytime that that's the case, at least in the at the district court level or the trial court level in state courts.
Yeah, no, it's interesting though, because when I think of people, all right, so there's some cases where the case makes it to the Supreme Court or it makes it to the cert stage for whatever set of reasons. And then at that stage, the sort of the professional amici, rush in and start filing their briefs saying, actually, this is a more complicated question than the trial court may have recognized. And here's, some set of constitutional or originalist arguments. There's other cases that are intentionally teed up over time, right? Like, let's get a vehicle in front of the court to rethink nationwide injunctions or whatever it may be. And can happen in a slightly different way. But at core, when I think of the groups that I would think on average have been more likely to get originalist arguments to the higher level courts, where at least I hear about them once they make it there, I think of one of Will's example, like state solicitor general's offices, particular impact litigation groups, and to be blunt, I would think that many of those groups, whether or not it's the state solicitor general or like particular impact litigation groups, are often maybe more likely to be right of center groups or have some of those connections. However, when I think of like the modal public defender, I assume that the modal public defender on average is less likely to be conservative and less likely to be an originalist themselves. And what we're talking about right now is like, here's all of these avenues for a new line of argumentation where sort of methodologically, philosophically, the people that are in the position to make the arguments, for the reasons I just said, are not necessarily the people that would have been like into those arguments in the abstract or, methodologically or something like that.
I hear what you're saying, and I don't want to be, I'm not trying to be what my mom would call a nudnik.
A what?
A nudnik?
I do not know that phrase. What is, for those of us that don't know your mom,
you're going to hear. So, when you have a client, you have to defend your client and you have to advocate zealously for your client. And so, well, I'm sure there are surveys out there about public defender attitudes, and we don't need to sort of get into sort of the intricacies of that, but public defenders come in all varieties and all types. There's certainly left-wingers, there's right-wingers, there's in-betweeners, there's libertarians, there's all sorts of people are public defenders. And what we all have in common is zealously advocating for our clients. And so I think you're right that there's historically at least, there certainly has been an ideological valence to originalism. I think that's even maybe the gentlest way of putting it. You could even say, of course, originalism is the product of a social movement with a social legal movement with the goal of enacting right-wing legal change. I mean, that's sort of...
Yeah, Will's about to tell us about, 1930 Justice Jackson or something like that. And
he disagrees.
Yeah, right. Yeah.
But even so, an idea starts one way and gains traction, and then anyone can use it. And regardless of the original purpose or the reason that someone developed it, the sort of ideas that have legs can escape the intentions of the social movement that was sort of trying to push it. I think we saw this to some degree with Law and Economics, which was also founded as a right-wing social legal movement. And there's books that sort of document it. And I'm persuaded. I think that is an accurate description of the origins of the movement. But there was also some really good and important, maybe not morally good, but kind of accurate sort of points that were made. And now I don't think it would be accurate to say that Law and Economics is a right-wing political movement within the courts or within the academy.
Yeah,
And
it's not anymore. No.
so anyway, that's a long-winded
one of the
answer.
things that our class made concrete is, so in the area of criminal procedure in the Supreme Court, there are multiple examples, some 20 years ago, some just a couple years ago, where an originalist criminal procedure argument prevails and helps, a convicted criminal who conservatives are presumptively not very sympathetic to, and accumulates a kind of cross-ideological coalition of justices. So Judith mentioned the Crawford and Booker examples, the Confrontation Clause in sentencing 20 years ago, where you see Justice Scalia and Justice Ginsburg like get together and both agree
Yeah.
on this. There was a case called Ramos, litigated by Jeff Fisher just a few years ago, where Justice Gorsuch and Justice Sotomayor did the same thing to talk about why non-unanimous juries were unconstitutional. So one of the striking things about this is just an area where sometimes, for whatever reason, it works. Now, maybe that's proof originalism isn't as ideological as it seems. Maybe it's just proof that ideas have consequences. Even if it's a small number of examples, those parties made us see that there are at least times when these arguments work, and they work in surprising ways. And so you have to figure out how to make them.
All right, let me ask this. How do you think about your audience if you make arguments like this? And here's what I have in mind. You could imagine that your audience, if you were like you, Judith, in your clinic's work, have the defendant on, like a prospruin gun charge of some kind, one of these, whatever it may be, and you're trying to decide whether or not to make an originalist argument. Are you thinking like, will my, trial court judge be sympathetic to originalism, either because of what you know about their political backgrounds or just because they understand, to put this in Baudean terms, that originalism is our law, or whatever the positive claim is in 2025, something like that? Or is the audience the jury, if that you think that they're going to be persuaded? Or are you thinking to like the next level, like the circuit courts, or even in some instances like appealing it all the way up? In other words, would you think about who is sympathetic to originalism?
Yes. No, I'm not trying to be flip, but the goal is to win.
Sure. Okay. Yeah.
And so at least in the world of criminal defense, you want to win the first time if you can. Because as soon as you get to the Court of Appeals, well, of course, you've inherently lost, but you've already lost once if you're getting to the Court of Appeals, and it's difficult to overturn a verdict. Or even courts don't like to overturn guilty pleas if it's like a conditional plea, a plea where you reserve a legal issue that you're still allowed to litigate on appeal. And then if you get to the Supreme Court, well, now you've lost twice. And the Supreme Court is even more reluctant to sort of overturn something. Even a lot of the wins at the Supreme Court, ultimately, it's the Court of Appeals who then has to decide whether this changed legal framework means that an individual client should win, should win, whether a verdict should be overturned. So I guess to answer your question, it's really all of those things at once, but I don't think that it's really disentangled from the issues that litigators face all the time. When you're litigating in district court, you're thinking about the audience you're litigating for in front of right now. And then you're thinking also in terms of the audience who you may have to litigate for if you lose the first time around, if you lose on this individual issue, if you lose on the overall big picture issue, and even potentially the Supreme Court. So when I'm in the clinic, when we're teaching our students, we're trying to always, of course, build into the record and build into the litigation that we're doing, essentially build in appellate issues and look for places where we can raise appellate issues, even if they may or may not be successful before the district court. That said, I want to win in front of the district court or in front of a jury the first time around, so we never even have to get to the appellate court. And it's sort of interesting how much I think that there's this perspective that law school creates that all of the action is in the Court of Appeals or the Supreme Court. But of course, I hate to say that's not true. And a lot happens in the district court, and a lot of district judges, they will pay attention when you raise a real argument that is a new argument that you've thought through and you're presenting evidence. they will read your brief. They will think about the sources that you cite. Sometimes you have to attach the sources because they don't have access to the law library, that they don't necessarily have access to the same kind of law library and resources that we have. And they'll pay attention, and sometimes you win, or sometimes you get far enough to change practice, even if you don't win, and to change what's happening either locally or around the country. So I think the audience matters, but it's not sort of choose one or choose the other. You have to be choosing all of them at once, essentially.
Yeah, I mean, let me just say that one of the points that you raised there, Judith, I think is a great point that I'm constantly reminding students of, is that they show up in law school and we read these appellate cases, and everyone's sort of like prestige radar goes off, thinking that they need to gravitate towards what's happening at the appellate courts. And I feel like I'm constantly saying it's both more interesting and lucrative to get closer to the trials, and you have to fight against people's other concerns to convince them of that. All right, I'm going to switch in a couple minutes to leave 15 minutes for a Q&A here. So if you have questions, please go ahead and enter them into the Q&A. We've already got a few, but I'm going to ask one last question before I switch to Q&A, which is this. So you said at the start, this seminar was unique in that you were able to get permission to choose among the students that applied for who you selected. And intentionally, you tried to get some students that you thought might be more interested in originalist methodology, and perhaps some students that more had a background in litigation or trials or the clinics, et cetera, and get all these different students with different ideologies, backgrounds, career goals in the same room. My question is, once you got all the students in the same room, did they sort of coalesce around thinking around this the same way? For instance, you could imagine that like everyone, the students that are the clinic students and the students that are like the hardcore originalists, all just sort of started talking like Judith just did in the last answer, like, we're here to win. We all agree that let's do the best originalism, and so we can get clients good outcomes. Or was there like sustained disagreement about how to think about these questions among either the students or among yourselves?
Great question.
Yeah.
I think the biggest difference that was perennial was sort of like what people knew about. There were students who had read every article Larry Solom or Randy Burnett had ever read and could like immediately tell you, well, this fits into Solom's theory of whatever. And then other students who were maybe less steeped in that stuff were like, explain that to us. And similarly, there were maybe other students who had actually had experience, like working on litigation, and had to like explain a little more. So I think there was like definitely there were noticeable differences in background knowledge. But I think I was struck. Judith may disagree. We haven't pre-gamed this question. I was struck by how much everybody was mostly coming to it with yes, but how does it work? Like,
yeah, right. That's my question.
What do I point to? Where do I find it? How does it work? Why does this work? I mean, one thing we did in the class that I think students have not done in many of their classes was just we read a lot of briefs. And so they spent a lot of time reading briefs, and they'd be like, this brief won? This brief was terrible, or whatever. So I think a lot of them were really focused on just the
nuts and bolts.
Yeah, how do you do it?
Yeah. And I think that also meant it's not that people didn't disagree, but a lot of the ideological, and I don't mean those are not real, a lot of the sort of real and deep disagreements, we sidestepped a lot of them because we really were highly focused on just what do you do? If I'm gonna help a student learn how to stand up at a podium and make an originalist argument, what are the words that are going to be coming out of their mouth that can be said with some kind of integrity? Or what goes in the brief? What's a better brief versus a worse brief in this area? What are some strategic choices that are unique to originalism versus not so unique to originalism, that are just sort of part of the practice of litigating? Those are questions everybody was really interested in and engaged in those questions. And there wasn't such an ideological valence to those questions. And I also just want to resist you a little bit in saying the originalist versus the clinic students. We've had originalist clinic students, and there could be originalist students, originalist, not there's no like litmus test on originalism,
Right. I was looking at the two of you and the divide, and then being like, your students and your students or something. But obviously, it's not that simple. Yeah, that's fair. All right, I'm going to go to some questions here. All right, so one kind of question that there's a few different variants of is functionally something like, how do you find originalist arguments? Like, how do you even go about assuming that you're open to this? where do you look? And then a related question that there's a few variants of is something like, what do you do if the record is ambiguous, non-existent, indeterminate, etc.? Given that you have this sort of combined obligation to help your client, but also to be accurate in the information that you provide to the court.
All right, so two thoughts on finding originalist arguments. So one is, one thing we did in one of our sessions was really just like a how-to, like come up with a topic and let's sit here right now on the computer and try to like start finding sources and show how you do it.
Yeah.
Risk of advertising. I have a document on FSRN with Judd Campbell called A Source Guide to Early American Constitutional History that just walks through all the different kinds of bodies of sources there are with links to all the ones that are available online. A little knowledge is a dangerous thing, but like we started just like trying to do that. Okay, let's see what we can find. What did the founders say about whatever? I think one lesson I took away from the course is that it is much harder to litigate an originalist argument if you are coming up with it for the first time in trial court. The arguments that have been the most likely to succeed are either where there's already a doctrinal framework that asks for these arguments, like Bruin and the Second Amendment. So there are like lots of new trial court litigation about, but is this gun law constitutional? Is this gun law constitutional? But the kind of question has been set by the doctrine, and so it's easier to know how to answer the question. Or where there's a literature where somebody, at least some scholar, has said, look, the rule against unanimous juries has its origins in the racist constitutional convention of Louisiana in 1895, and that's a problem. And so you would have something to draw on, so you're not just trying to reinvent everything. And I think it is just very, very hard if you don't have either of those things to reinvent the wheel on a litigator's timeline of resources.
Reinvent the wheel.
Really.
Yeah. You might be able to reinvent the wheel, but you're not going to be able to invent the wheel.
First wheel is a lot harder.
Yeah. Got it. All right. Here's another kind of question beyond just finding the sources. Is there anything weird created by the fact that, at least in a criminal case, that the prosecution can't appeal if they lose the case? Does that create some, before I use the term adverse selection, I'm hesitant to use it now, some selection that occurs, whether or not adverse or not, as a result of that, or any implications of that on the kinds of arguments that are either raised or that make it through the court system?
Well, I mean, the truth is the government actually can appeal a lot of the time, and there's a complex doctrine that's developed that I have to admit that I have to look up the intricacies of it anytime this actually comes up. But certainly if a case is dismissed pre-trial, the government can then appeal that. And so actually when I started in the clinic and then co-litigated this was Allison Siegler and some panel attorneys like Matt Madden and Steve Saltzman here in the Northern District of Illinois and the Federal Defender Office. We came in on an appeal in a set of cases we were working on where the government had asked the court to dismiss the case pre-trial, and then there was a discovery ruling that was favorable to the defense, and the government had asked the court to dismiss the case pre-trial. The court did, and dismissed without prejudice, and then the government appealed it. And so at least in the Seventh Circuit, that is permitted. But the point is that depending on when in the criminal process the case gets appealed, and then even post-verdict, depending on what the judge rules on sort of the motion for directed verdict and those kinds of things, there's times when the government can appeal. And I haven't actually thought through the details of what your question is, but I wonder if it wouldn't surprise me if a lot of these originalist arguments do end up appealable by the government if the defense wins.
Yeah, one question that came up in the Q&A that's actually related to where you just ended there, Judith, is can you just entirely start these arguments essentially at the appellate stage, either through amici or other means, or it's setting aside the Supreme Court cert stage at the circuit stage? Do the circuit judges really want to have seen the argument developed at the trial level, or are you able to introduce it at that stage through one way or another?
I think so far the answer seems to be that yes, you can do that. I don't know how long that's going to last. And I guess the reason this is sort of somewhat speculative, but my sense of appellate judges is that they don't love it when you sort of you haven't given the district court a chance to get it right. You haven't aired your arguments before to the other side at all. And so, I think so far it has been the case that folks have been able to raise historical arguments for the first time on appeal or even before the Supreme Court. And I wonder, as originalism becomes more common and sort of something that becomes, I mean, these are some predictions of mine, but sort of something that is more a part of a litigator's toolkit, whether the courts of appeals will start to resist those arguments, if they're sort of raised it wholly for the first time on appeal. Now, that's not, I think, where we're at right now. I think that what's the phrase? You have to preserve issues, not arguments. So that's sort of not, I think, not really where we're at right now. But I suspect that courts will be somewhat resistant as time passes. Although exactly what form that will take, I'm not sure. What do you think?
Also, I agree with that. So one of the interesting divides is also about like, are originalist arguments that need to be raised by the parties in the traditional way, or are these arguments more like jurisdiction is famously something where the courts are like, it's just about us, it's about our power, and so we have to assure ourselves we have jurisdiction. So some prominent originalists have argued originalism is kind of like that, and originalist judges should be making sure they're complying with originalism regardless of whether the parties raise it. I suspect that's not going to take off, but I expect there'll be some judges who are going to be attracted to that as a way of thinking about it. So I think we're still in the phase of everybody trying to work out how these work. And I think if litigating originalism continues to take off as an enterprise, I suspect we're going to get more of a set of expectations about how to do it, when to do it, what judges want to see when.
Got it. All right. One final question, which is, so as we've been discussing, originalism is something that you think of more at the Supreme Court stage or at the appellate stage, or really in a lot of academic articles, and less in the trial court cross-examination of actual criminal trials or things like this. Although, of course, there's exceptions in the ways that we've been talking about. But to me, in a sense, this makes, originalism till now has been a little more academic, a little more coming up when it's been sort of teed up by, Will Baude working for 5 years on Section 3 or something, and then it makes its way into the court once people know there's this academic base. The question is something like this. Does the actual litigating at the trial level, where now we're seeing the sausage get made, so to speak, changing anyone's views on the sort of underlying merits of originalism? In either direction?
I don't know the answer. I don't know that I can answer that question. But I will say that teaching this class convinced me that the critique of originalism, the sort of practical critique of originalism, that this is no more determinative than anything else, and is just immensely difficult to muster the resources to make these arguments, is accurate. I think that's right. That does not necessarily mean that we don't do it. I mean, for me, here I am teaching this class, but just trying to engage in a good faith way with what the Supreme Court seems to say we should be doing is very hard, even with the resources of a law school library and sort of the historical resources of a law school library and a law school clinic and students. This law school clinic with sort of extraordinary students who are happy to go down those research rabbit holes and can understand and put things together. It's very hard, and that I think if this does become a big part of litigation practice, it will be very resource intensive, and I don't see a way around that. I think that's an important lesson that's real and meaningful from the district court level. But that's also something that's a critique that's already been made. I think we saw that in the Supreme Court, the gun cases in Bruin and Rahimi. That refrain was something that sort of the justices know about, and here we are going down this path anyway.
And I guess one other thought is that I think it made me think that a lot of the thing that constitutional law scholars love to do most, which is to debate like normative questions of theory.
Mhm.
Uh, is originalism only partly relevant? Is it always relevant? Is it our law? Is it only part of our law? Should it be original public meaning or original whatever? Are less fruitful sometimes than just like finding out some stuff people didn't know about the
Mhm.
history and presenting it in a compelling way. And that turns out just to go a long way. And
Mhm.
I think there's something, the first kind of arguments are fun and maybe a little easier. The second kind of arguments maybe pay off more in the long run. But it can even sometimes cross-cut like a lot of the other questions, like how much weight should we give this? People will argue about that forever. But look, I learned something about how juries worked in the 19th century. And, once you know that, like you can't unknow it.
No, that all makes sense. All right.
Mhm.
So I think I'll stop there with questions, but let me just say a few things here before we wrap up. So the first is one kind of question that we had quite a few different versions of was sort of at the stepping back as level and saying, why originalism? Why should we be originalist? What's the merits of this underlying theory? What does it mean to be an originalist? What does it mean to be conservative, etc.? So one thing, some more self-promotion on this. Will and I recorded a podcast series that was something like 6 or 7 episodes long back during the pandemic, where we just argued back and forth for each episode about originalism. And basically the conceit for that is, spoiler alert, I'm not originalist. And Will is. And essentially I tried to push him on why would someone be an originalist? And we tried to have a conversation like this over about 7 arguments about different aspects of originalism. If anyone is interested in either that podcast series or Will had mentioned the resource guide that he and Judd Campbell have put out and other resources, if you send an email to the alumni email list, which was at the bottom of the invite for this event, so this is alumni@law.uchicago.edu, we can send out to anyone that's interested the prior podcast series, the source guide, or some of the other materials that we've been discussing at this event. Now, final thought before we wrap up, which is I hope that this conversation highlights something that I think is particularly special about the University of Chicago, which is we're able to bring people together constantly in the classroom and discussions outside of the classroom over lunch that have fundamental methodological and substantive disagreements about the nature of constitutional interpretation or what is the law, et cetera. And in my experience, in years and years of these conversations, it's still been civil and interesting 100% of the time, despite doing this, on a near daily basis. And I hope that this is the kind of discourse that we're exposing our students to and continuing to model going forward. And for the admitted students on this Zoom today, can't wait to get you guys here too, so we can have some of these conversations in person. All right. Well, thanks, Judith. Thanks, Will, for doing this with me. And thanks all of you guys that tuned in today. Hope to do this more going forward. And if you have feedback, please feel free to email us and let us know so we can improve upon this idea for future sessions. Thanks, everyone.
Thanks.